And we are live. So let me make sure we have any attendees. There we go. Now the attendees are starting to populate. Welcome to the Ad Hoc Commission on the Discipline System Effectiveness Subcommittee ENEC Working Group. This meeting is called to order, and I will now call for public comment. It looks like it is all staff in the attendees list, so I don't see any public comment, but if staff would like to make a comment, they can raise their hand. And they do not. So I will share my screen, share my PowerPoint. So we can all see the screen, correct? Oh, I've got it presented. There we go. So this is going to be a brief reminder. This is the ENEC working group. And this is our current timeline. And I went over this at the effectiveness subcommittee, so it's a repeat for that. But it's the full ad hoc commission is going to meet in September. The expungement working group met last week. This is the first working group of this. This is the first working group for ENEC. We have the moral turpitude working group meeting later on this week. And then we're going to schedule working groups all the way throughout for the next couple of months to drill down. There will probably be another, we currently have 4 working groups because there's a diversion working group as well. And there'll probably be another 4 working groups ultimately formed for various different issues. And they'll be doing their work from September on through January. And then we'll have a couple full ad hoc commission meetings where those working groups will bring back the recommendations that they developed and present to the full ad hoc commission for adoption or revision. And then the full ad hoc commission will meet in May and June because the report is due in June of 2022. The agenda for today's meeting is to kind of set the scope for what the ENEC working group is going to do. And then also what kind of data is required for them to make decisions that they may make. And then I also wanted to try and schedule meetings. And some of the other working groups we've had, we schedule the meetings kind of like on a regular basis. So every other week, if we could maybe find a time that we could all meet. And if we don't need that meeting, we can always cancel it, but it's easier than drowning the committee members with doodle polls. So if we can, at the end of this meeting, kind of set up a regular check-in, that would be a goal as well. So it looks like Ed has joined us. I don't think I called the roll. So I will call the roll of the subcommittee now. Melanie Lawrence.
Here.
Judge Wang.
Here.
Linda Schneider.
Here.
And Ed Lear.
Here.
Everyone is here. And so I'm going to stop sharing my screen so we can see each other and have a conversation. And so initially the ENEC discussion revolved around the criminal conviction, the C cases. And that's where Ed had proposed that some changes be made, that there be changes to the process where that is a possibility. So Ed, I don't know if you want to add to that or discuss specifically what you're looking for. And after this discussion, I'm going to turn it over to the other members of the subcommittee. If there's other processes in the ENEC, sphere that we would also want to look at. So Ed, I'd turn it over to you first.
Thanks. And I think everyone's heard what I've had to say about this topic ad nauseum, so I really don't need to add to that. I'm more interested to hear what others have to say. So I'll just pass the microphone back.
Okay, thank you. Melanie, do you want to start off, or Judge Wang, or anybody?
What are you looking for?
for feedback on the concerns, what you think about the C cases being part of the NEC, just kind of a discussion on the C cases and the NEC piece.
Okay. Well, I mean, I'm mindful that the issue of criminal conviction cases can't be discussed in a vacuum. So, you know, the C cases start differently in our office than regular original discipline cases. And so there are some competing interests. And one of the competing interests that's foremost on my mind is that there is a statute that requires our office to transmit within 30 days of receiving a certified record of conviction to the review department. And that's what begins then the public proceeding. So I think, you know, if we're going to talk about doing ENECs differently, including adding them as part of a C case process, we have to figure out sort of how those two interests work together.
Okay. And just so I'm clear on this, because there are certain cases that aren't sent over to the review department. So there's a little bit of discretion there.
Yeah, so the statute basically requires us to transmit when it appears that either per se or in the facts and circumstances, it's per se moral turpitude, or in the facts and circumstances, it's moral turpitude or other misconduct warranting discipline. So if we receive a case, by way of example, we might get a DUI conviction. That's a first time DUI conviction without any factors in aggravation. And we know that under California Supreme Court case law, that is unlikely to resolve with discipline. So we wouldn't transmit that kind of case. But we would transmit, for example, a second time DUI, because under the case law, it does warrant discipline. So.
Okay. So this would require a statute change if this recommendation was adopted by the full Board of Trustees, and it would need to go legislature to allow you more time, because right now it's the 30-day deadline. So we would need, it's not realistic to think that we could do an ENEC within the first 30 days of notice. Is that what I'm taking from
That's
that?
right, yes.
Okay. Judge Wang.
I think I threw this out there, and I don't know if this would be a fix. I agree. Well, what Melanie's touching on, I'm sensitive to this. When it gets certified to the review department, it becomes public. So there's a public notice issue. So I understand the competing interests, but I think a workaround is an amendment to the rules of procedure so that once it's certified from the review department, sent to the review department, review has the power, if we change the rule, to say, now we're sending it to the hearing department to conduct an ENEC. I don't know, like I said, I think I threw it out there as an idea, but I need to take a closer look at the statute and our rules to see if we would be offending something. But of course, this is, you know, back to Melanie's point, you know, the State Bar wants it out there. They don't want, you know, they want the public to be on notice. So that would be the competing end of it. But if the ENEC is we do a confined period, then I don't know if there's a public protection issue in like a 2-week delay or, you know, a 3-week delay. So that would be a potential workaround. And obviously I don't know what OCTC does from start to finish and how complicated that referral process is, but I think a lot of this has to do with the fingerprinting en masse fiasco. So I am cognizant that I have been getting, and this is anecdotal, been getting a lot of conviction referral matters. And what happens is in a lot of these older cases, they'll end up dismissing it actually, because what OCTC gets is, you know, the final transmittal. So they do what they can, get the records. They don't have the underlying police report necessarily. They don't know all the factors that are going on. So I understand why they send so many things along. If there was a domestic violence case that was pled down to a trespass or a, disturbing the peace, I understand why OCTC wants to investigate, because there might be something else going on. But so those are the complications, and I might have thrown out more problems than where we can answer right now, but those are kind of the competing interests involved. But I don't see a huge issue by building in, like an extra 2 weeks or something like that. I don't know, Melanie, if you have thoughts on that.
Well, I don't know. Well, it depends on if you mean an extra 2 weeks prior to our transmittal, because if that's what you mean, I don't see that realistically as a possibility. What could happen if there was a way to amend the rules is to build it in after the fact.
Right.
Of course, yeah. Okay. So of course the challenges with that, it's an interesting idea. I think the challenges with that would have to be sorted out. Or one, I'm not sure if it accomplishes what maybe ADDC is interested in. Not sure, but in any event, I think one of the other challenges, and I know we're not here to talk about it, but when it comes to conviction matters, and I think ADDC would say this too, is that they are on they're on an expedited track in any event. And so there really isn't much of an opportunity for either party to really, do any kind of investigation. We would have to ask the court to take depositions, for example. And I think that they're required to be set within 4 months or something like that. Whereas in most other cases, we've had an opportunity to do an investigation first. So everything is sort of compressed in there. So I think that's part of the challenge as well. But yeah, I think an idea of it's not really an early neutral evaluation conference, since it's becomes a public matter in any event.
Well, so I have a question for both of you, Melanie and Judge Wang, based on something that I've heard recently. And it actually came up in one of my cases today. And that is this idea of the OCTC dismissing a case that's pending and then entering into a private approval. And I've just heard about this very recently. I've heard that it's done. I've never heard of that before. It somewhat addresses my point, because what this is really all about, at least from in my head and from the defense perspective, is the opportunity for respondents to avail themselves of a private. And that's, so if there's let's call it what's the case that we all agree is actual suspension, like a burglary. Okay, moral turpitude. Got it. I mean, it'd be the rarest of circumstances where that would end up as a private in my mind. But let's just assume, for the sake of my argument, that the burglary is going to be some kind of public discipline, versus the 2 DUIs that are 0.08 and 0.09, which with no extenuating circumstances, reasonable minds can agree that would probably be a private. And it's in that circumstance that I think that those respondents should be afforded the opportunity of a private. It's a pretty small subset. And with respect to public protection, we probably all agree that the 2 DUIs, depending again on the circumstances, less of a public protection issue than the burglary. So if we just start with that, then I'm not even convinced that an extra 2 weeks wouldn't make a big difference, because how much is there to investigate? That shows you how little I know. But the Judge Wang's idea is fantastic. The workaround being with the rules of procedure rather than having to go to the legislature and change the statute. I think that just makes it easier. But Melanie, from your point of view, let's just take my 2 DUI case. If there was an extra month, would that make an appreciable difference in allowing you to finish your investigation so that we could have an ENEC that would be, what would that be, like 60 days? 60 days after the conviction referral the conviction was referred? I don't know if I said that right. I'm just working with the timeline. So
yeah, I'm sorry. You're using the term ENEC, which I know is the topic of the conversation, but I'm struggling a little bit, of course, because we have settlement conferences in conviction cases. So I'm trying to figure out what would be different about an ENEC 30 days after referral.
Oh, sorry. Okay, then maybe I misunderstood something. I understood Judge Wang saying that there's a workaround with the review department. Okay, let me ask the question. I feel like I should know the answer, but I don't. Once the criminal conviction is referred to the review department, okay, then my sense is that then that's public at that point. Does everybody agree with that?
Yes.
Okay, then
Does it
Judge Wang, I
have
didn't
to be?
understand your point.
Well, I don't think it has to be. There's nothing that says it has to be public. The statute says it has to be referred. I mean, the review department has a private calendar all the time. I can't even see the private calendar. So, and I have Odyssey. So they have that part is private. They determine on their WCC calendar whether or not to refer to the hearing department. I don't see why that prevents us from holding an ENEC. It's just triggered under 6106 and 5.340. That to me, that's
Okay, so I did understand you correctly. So,
yeah.
so Melanie, I think what Judge
Maybe
Wang
I
and I
didn't
are
understand.
understanding is that after OCTC does what it needs to do, which is refer the criminal conviction to the review department,
Right.
it's not public, and there's a window there for an ENEC. There's a window there for an ENEC if we do this workaround with the rules of procedure, I think.
Frankly, Melanie, this is my observation. Of course, this is anecdotal, but there's the idea of justice, and then there's the idea of proof issues, right? Those are two separate things. So in these older convictions, you know what? There probably is moral turpitude, but you can't prove it because we've lost the complaining witness, we've lost the police report, there's no physical evidence anymore. And if you have a 2-week window, at least you can make that assessment about proof issues. I'm not a deposition. They are two different animals, the O cases and the C cases. But, with a small window, I think a lot of these cases can kind of thumbs up or thumbs down.
Okay, so now that I'm understanding a little bit better. So I don't know if there's a way to make the matter not public once it's transmitted to the review department. Maybe that's clear to everyone else, but it's not clear to me, but maybe, let's just say for the sake of argument, it is. I will tell you that I would be concerned about 2 weeks. And I say this because, well, first of all, we can rarely ever get in for an ENEC according to the rules in 15 days in many cases. So I don't know why this would be different. So, I mean, in some ways, I guess maybe we would end up with more time, but I'm not sure that 2 weeks is really realistic on that point. But also, I mean, let's be clear that during the period of time where, and especially with these older cases, where we become aware of them, we're doing a lot of things. One is that we're working on getting the certified record of conviction. But the other things we are doing is trying to get the underlying documents. So whether it's a police report, something from the district attorney's office, et cetera. And so, I mean, and sometimes we've spent considerable time, and for a variety of reasons, especially on the older cases, it takes time. One of them just is given the impact of COVID, there are some courts that are still quite slow to respond to us. So I don't know that, I don't know that realistically 2 weeks is going to make any difference to us in terms of, you know, whether or not we're able to get those underlying documents. Maybe we would just need to make a judgment call at that point, at the 2 week mark, or at the ENEC statement, the ENEC mark, whether or not we could go forward or not, or just cut the losses. I don't know. But I guess those are my thoughts. I'm just not even sure how realistic getting in 2 weeks really is.
I only gave that as a marker because
Okay.
of what the ENEC is 15 days. That's why I was throwing it.
Right. Yeah. So I guess,
Okay,
yeah.
Melanie, can I ask you a question?
Yeah.
I think it's important for all of us to understand the process, and I thought I did, but I guess I don't. So criminal conviction, so your office learns about the finality of a criminal conviction. And if I understood you correctly, you have 30 days after finality to transmit?
No, it's 30 days after receipt of the certified record of conviction. So it's not necessarily about finality.
Certified record. Okay, and that's what I think Brandon Taty's doing that now, right?
He's retired.
Oh, I didn't know. Okay. Okay, so 30 days after receipt of the certified record, within 30 days, it has to go to the review department.
Right.
And then what I'm hearing for the first time, that the review department can sit on it, I guess, without it being public.
That's what I don't know. It sounds like you. Okay, Justin.
No, I think I'm hearing that this is, you know, Judge Wang doesn't see anything, but I think that this is something that I might need to take and research and go after and talk with like Erica and people, just, or unless you're very confident, Judge Wang. I was off.
No, what I meant was they have their conferences that is on their confidential calendar. So I don't see it until it's sent to me. So whatever considerations they're making in their referral process, I don't see.
Okay.
Okay, and anecdotally, I'm thinking about a case that I have right now where there was a transmittal, respondent was made aware of the transmittal, but there was not, it took over 6 months for the review department to issue an order. And that might suggest that there's a period between the transmittal and the order where we should be having an ENEC. So we do need to figure that out.
Yeah, and I don't know what the circumstances of your case was, but that sounds like, if it was a felony case, it sounds like the potential exists that, I mean, on felony cases, we would be, or any case, we would be transmitting, and then there has to be finality. So sometimes after we transmit, it does take many months until there's finality or the respondent waives finality before it ends up going to the hearing department.
Okay. All right, but so Judge Wang has made the most interesting point of all, which is that it may be that the window of opportunity is after the transmittal and before there's an order. If we consider that to, well, okay, back to Melanie. In that interim, after the transmittal and before the review department order, if we were to have an ENEC, could we do a private, or is that already public?
I think that we have to answer that question. Is the transmittal of the review department make it public?
Okay, fair enough. Right, because if it's not public, then that's exactly the window to have the ENEC. If it is public, then we have to go back to talking about the statute, which is the 30 days, which really doesn't give much of an opportunity for an ENEC. We all agree. Okay, interesting.
Well, an analogy is, okay, so when OCTC files an O case, so they file the NDC as it's that time in which OCT has transmitted the NDC to the state bar court. It hasn't been filed until the NDC is filed. So so the transmittal to the review department shouldn't necessarily become public during that inchoate stage. You know what I mean, Melanie?
Yeah, I mean, I guess it depends on what, I mean, I just don't know what the court process is.
I don't either, but I just know it doesn't become a case until we file the notice of hearing on the respondent. So that's why that what I'm calling the pre-filing stage doesn't necessarily have to be public.
Okay.
I don't know.
So let me go back to maybe where we should have started. I brought this point up, and I've only ever been thinking about and Judge Wang, you're right. This in my head borne out a little bit because of the fingerprinting cases, but even beyond the fingerprinting cases, I was only ever thinking about the opportunity for ENECs for criminal convictions. Is there anything that I'm missing here where we should be expanding the role of ENECs? I don't think so, because on any O case, there's a right to an ENEC. And if you don't afford yourself with that, too bad. Otherwise, it's there. Did I miss anything?
No, but I think OCTC's perspective is the parties will often ask for a second or third, or respondents and the court's calendar can accommodate it within 15 days. I mean, I don't know if I want to open up, or we should open up the can of worms, but
I appreciate you raising that. I think, because this is the subcommittee on ENECs, not just ENECs and criminal conviction matters.
Right.
Right. And so, Ed, to your point, I'm not sure that we see that it needs to be expanded in any way. I think that the challenges that we see to the existing format is one that it doesn't seem like it's realistic in terms of timeliness. I know the court has competing interests. It's difficult to get everybody on the same page with regard to a time when everyone's available. And yet the rule says, 15 days. I think that there's a feeling that, even when we've given notice, and if the respondent responds at some point, or we're trying to schedule a time, we don't really have much of an opportunity to force the issue, because if we file, we run the risk of a motion to dismiss, which we're likely not going to be successful at the review department on abuse of discretion. And what we're thinking about, and this goes to the repeated ENECs, is one, that the whole time that, but prior to the ENEC, the case is private, and there may be real public protection concerns that we have, and we want to advance it. Also, the fact that, for the entire time up until a filing, the case remains in our inventory and is counted in OCTC's inventory. And of course, that's a concern for us, because we are very mindful of the timelines and the statutory backlog and the criticism that comes with that. So, in cases where, in any event, the result is going to be public discipline, it doesn't make sense for us to continue to have multiple ENECs, because in our view, the ENEC process is partly to try and resolve cases early if they are going to resolve without public discipline. That's the benefit to the respondent. And also, obviously, there's a cost issue, and I recognize that costs go up after the filing, and that's a concern, and costs are high, and that's a concern. But this stretching out of the ENEC process is problematic for us.
I mean, my quick response to that is that's an issue for the court. I mean, isn't the court the one that has to essentially make the determination as to whether a second, third ENEC is appropriate in the context of all the circumstances? So we have a mechanism to address that. In other words, I wouldn't want, Melanie, if you're arguing for a bright line, you do your ENEC within 15 days, and if you don't get it done, too bad. You had your one shot at it. Let's go to the NDC level. I would oppose that, and I think the court would oppose that. But I think we already have a mechanism that uses its discretion in deciding when it's appropriate to have a second or third ENEC versus not.
And this brings up that's why I said can of worms. This also brings up, the pro pers versus represented. And I think I mentioned this, so the early neutral evaluation is different from a settlement conference, because the early neutral evaluation, that's when the litigants actually get an evaluation of the strength of the charges, right? That's my role as the ENEC judge, which is a little different from my role in settlement. My role in settlement is more a mediator. At that point, I'm not supposed to comment on necessarily on the strength or weaknesses of the case, and I'm supposed to be mediating because the charging decision has already been made. So I appreciate the separation of powers. So the ENEC is kind of, especially for the pro pers, it's their opportunity to understand, what this case is about and what they are potentially looking at if it proceeds. So that's where I kind of grapple, to be honest with you, Melanie, because a lot of the respondents, at least the pro pers, this is the first time they're hearing from someone else because they did not consult with a lawyer to say, look at the rules of procedure. This is different than, this is a very unique body of law. This is what you're looking up against. And for those folks, I feel I'm not giving them due process if they don't get a second ENEC. So that's where I struggle. So
I can totally appreciate that, and I can imagine it from your perspective. I don't know how to resolve it, just because, yeah. And I mean, I will say that, for example, our office highlights for respondents, throughout the process, well prior to getting to the ENEC, the import of, mitigation, et cetera. And so we feel like we've given those opportunities. I understand maybe it takes hearing from somebody else and it's a process for people to come around, but that process, butts up against, our interest in moving the cases because of timeliness and public protection issues.
That's what I was kind of interested in hearing, that the discontinuation of that 20-day, what was it called again?
Yeah, it was a 20-day meeting. And so, yeah, so it's something that our office, I don't think don't anybody quote me this, but I don't think it was required by the rules of procedure.
No.
It was a office policy that was in place for a number of years, and it was discontinued, I want to say maybe 8-ish years ago. And the reason for it is it really didn't give people an opportunity to talk to anybody else. If that's the concern that you raised, Judge Wang, it's still our office that they're talking to. And frankly, in too many instances, we felt like it was used as a delay tactic for folks. And again, being mindful of public protection issues and timeliness, we removed it as a barrier, given the fact that there is that ENEC process.
So let's go back to the criminal conviction referrals, which might be the easier one to start with. On that one, I think we don't quite have enough information today to really move the ball much, but are we all agreed that if there's a period of time after the criminal conviction referral to the review department and before the review department order to have an ENEC that would be non-public, that's what we should focus
on? Yeah, I mean, I think that would be something to look at.
And then what we have to be conscious of, giving OCTC enough time to do its its investigation, for lack of a better term, so that it can make a reasonable conclusion as to what the appropriate level of discipline would be from its perspective, and then give a reasonable amount of time to the courts to be able to schedule an ENEC. And well, that, I think those two primarily, and obviously defense counsel would need an appropriate amount of time to get together whatever mitigation is appropriate. And that would be the focus. Now, this is all wet if the matter becomes public as of the date of the transmittal. Then then there's no window.
I don't think there's anything, Ed, though, that requires that, though. That's what I'm saying. If it's, I don't know if it's, oh, Erica has her hand raised. She may actually have some answers.
I will bring Erica.
Okay, all right, okay.
Erica, you can unmute.
Hi, thank you. Just so for those who don't know who I am, I'm the projects attorney for the State Bar Court. So I serve as support to Judge Wang and Judge McGill for this commission. So I've been listening into most of the meetings. That being said, I believe that Business and Professions Code 6086.1 it's A to C. I believe that makes it currently that once the case, and in this instance, the record of conviction is filed in the review department, it is a public case. And so to have the E&E confidential in a C case, I believe would require perhaps a statutory change. Just wanted to raise that.
Okay, well, that ends that discussion.
Can you give me the provision again, Erica?
Yeah, it's so it's BMP 6086.1, and it's subdivision A to C as in cat.
So question for all of you. What process would we need to go through for a legislative change?
Well, I think that there might be several recommendations that come out of the full ad hoc commission that might require a legislative change. And the goal of the ad hoc commission is to make the recommendations. I mean, we're going to need to speak with stakeholders and vet some of these things. But I think that if the ad hoc commission has done, its due diligence, has researched an issue and really thinks that this should be a change that they want and support, and the full ad hoc commission makes that recommendation, then the board of trustees will obviously take it up. And if they believe that it should be a recommendation, then there are avenues that we can work with our lobbyists and work with the legislature about achieving that change in the rule or in the law. I don't know, Dag, if you have any other comments on this.
I think that's right, Justin. It seems like there would be, among the various different recommendations that the ad hoc commission would make, maybe various different legislative changes. And if the board approves those, then it's a matter of putting it before the legislature through our lobbyists and our staff who work on legislative affairs, and then convincing the legislature that it's a good idea. So
can I actually read the provision? I appreciate Erica's interpretation. I'm just going to read it though. Subject to subdivision B, blah, 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 blah. Hearings and records of original disciplinary proceedings in the State Bar Court shall be public following a notice to show cause. So, and then it says proceedings for suspension of disbarment under 6101 and 6102. So I think it's subject to interpretation when you're saying a notice to show cause, which is normally the language for original proceedings. But does that language get adopted under the 6101 or 6102? And I think that might be an open question, because they do use the language to notice to show cause, and the review department is the one who sends the order that initiates proceedings in the hearing department. So, I don't know. I'm just throwing it out there.
Well, so if Eric is correct, and even if it's murky, it sounds like at least one option here would be to recommend that 6086.1 A2C be revised such that that period before the review department issues an order but after it receives a criminal conviction referral would be considered not public. I think it's that straightforward. Then question for Dag. In your understanding of how the recommendations work from this commission, would it be possible to accelerate that recommendation, if it's that easy, to the Board of Trustees so that we don't have to wait a year and a half and to make all our recommendations? I don't know the protocol on how that works.
I think you'd need a lot of buy-in as to why this particular change would be so urgent. And yeah, so that's my first thought on it. The other is just that I think the legislature, the state board isn't viewed in the kindest terms by the legislature. We really struggle in our relationship with them. And the fact that we make a recommendation to them, and we have made many recommendations to them that that make a lot of sense, does not guarantee in any way that the legislature will go for what we are proposing. So I don't know how this would play with them politically or how they would view this. But that's just my impression of them.
Very insightful, and that gives me a little more context as to a discussion that I had with Ruben and Sean about adding public members to our commission, because their view, maybe the greater board's view, is that for our commission to really have any teeth, we need more buy-in from the public. And so that was at least from an optics point of view, their grand thinking insofar as presenting any recommendations that we may have. So I'm understanding things better. Thank you, Jack. All right, so that said, what else on the agencies?
Yeah, I want to, it sounds like we could research this a little bit further to see if there is, I mean, Judge Wang, you said it's kind of open for.
Yeah, well, actually, now I'm going back to Erica because on 6101D, the proceedings to disbar or suspend an attorney on account of this conviction shall be undertaken by the Supreme Court upon receipt of the certified copy of the record of conviction. So I'm going back with, sorry, Erica. I'm going back with, yeah, I'm going back.
Okay.
Oh, I was just going to say that the conviction, the record of conviction, and Melanie will know this better than I, but that is treated basically as the NDC for these cases.
Yeah.
So that is under the B, subdivision B exception, Judge Wang, that you raised. That it's more or less the same document.
Okay.
So Justin, I don't know, or Ed, if we're done with this topic, or I wanted to raise an issue on the NEC.
I think we're done. We can move on to another topic.
Okay, so and it sort of goes to what I was talking about earlier in terms of, you know, the challenges that OCTC sees with the current process. And, you know, I think it's something that would be helpful in terms of evaluating just NECs generally, is something that we've talked about other processes as well. And that's, I'm wondering if there is a way to get information about how effective the ENEC process in fact is. Because I feel like a lot of times we all have our own experience of whatever the process is and feel things about it. And we have anecdotal examples, but I think what would be helpful is to actually see some data. So, you know, For example, in the cases that go to ENEC, how many of them actually resolve prior to a filing of a notice of disciplinary charges? Is there any difference in the success, if you will, of ENECs in pro per respondents versus not? Those kind of things. Is there a way to get that information so that we
Well,
can actually evaluate the
that's,
process?
the second part of the agenda where I think
Oh,
those
okay.
are the specific, no, we should move into that. What the working group requires in terms of data. So you just kind of said two things, and I want to make sure Lisa, we'll kind of turn it over to Lisa that she gets down the specific things, but are there things that the working group would need to kind of evaluate these things? So Lisa, it sounded like Melanie made two requests there.
Yes, I think I got them, but maybe you can say the second one again, Melanie?
Well, I don't think I articulated it well, but to Judge Wang's point about, pro per respondents, I'm wondering if there's a way to cull out pro per respondent ENECs versus others to see how successful those are to resolve cases pre-NDC filing.
Okay.
And I would open this up to the full working group if there were any other information that you would find useful in making decisions or recommendations.
One other thing I would be interested in, given the issue we have with time, is knowing, at least on average, how long does the ENEC process take from the time, I guess, that it is requested by the parties versus a final resolution, whether that's a resolution by stipulation or filing a notice of disciplinary charges.
I agree very much with Melanie. I think these statistical parameters would be really important to analyze, because just again, from my perspective from across the pond where there is no ENEC process of any kind, this is something particularly unique to the state bar, where attorneys have this benefit of having almost like a preliminary hearing, so to speak, before disciplinary charges are filed. So, to know how much time this process is taking and how effective it is, I think would really be critical.
Okay, what were the two outcomes, Melanie, that you wanted to see? Like, how long does the ENEC process take to reach the milestones? Was that
right? Well, I think what we're interested in knowing is from the time an ENEC is requested of the court to schedule with the court, to the time that there is the next step in the process, which would be a filing of a stipulation or a notice of disciplinary charges. If there's a way to do it, another possible result could be a closure of the case with no actual public filing.
okay?
Okay. I don't see anybody's hand raised or any other requests.
Justin, do you want to go through like the things one more time, the topics one more time, to see if we if there's anything that'll get people thinking? Like, for example, the criminal conviction. Like, Ed, is there any data you've just been like dying to know with regards to criminal convictions and ENECs?
So in thinking about it, the one that would be most interesting to me, and I don't know if it's kept by anybody, but how many public private approvals are there versus, well, let's just start with that. That's really what I'm talking about, is trying to make all private approvals private. And I'm the one that lost the case with the Supreme Court, just so everyone knows. The Mack case, way back.
So just for purposes of the staff, you're talking about all public privates, regardless of the kind of case.
Yeah, let's start. Okay, thank you for that clarification. Let's filter that down just to criminal convictions.
So for all criminal convictions, what percent results in different types of outcomes, including what's a private, how many get a private reproval, how many get a public reproval versus disbarment versus?
Well, not even that, Lisa. So here I am beating the drum about trying to get my clients privates in the criminal conviction context. I might take a really different view if you tell me that there were only 2 public-private approvals of criminal convictions in the last 3 years. Okay, I think it's a lot more than that. And because of the fingerprinting, I feel like I've had several of them. So I think it would be more than 2, but I mean, how many is it really? Because that's to a degree what I'm trying to change, is I'm trying to avail respondents of the opportunity to have privates versus public-private approvals. And then of course, there's the cost issue. So there's that, and it's not inconsequential, but primarily trying to create a situation where there would be what everyone would agree that on the spectrum, a private misconduct that results in a private approval is less serious. And so in those circumstances, I'd like to have my clients be able to have and not have their private approvals on the membership record. So how many are we talking about? That's my question.
You want to know how many criminal convictions resulted in a private approval?
Correct.
Sure. Yes. I think simplifying it. Yes. That.
Are you okay, just to be clear, are you talking about a public private approval? Because most criminal convictions, if not all, are going to be a public private, because they're already public by virtue of them being transmitted.
I think that's what he's
Yes.
Yeah.
for. They're
Yeah.
all
Okay, I just wanna make sure.
cases, but they end up, the discipline level is private, right? And so that's what he's looking, if I'm hearing
Correct.
it.
Yes. Correct.
Okay.
Yeah. Let's just start with that. How many are we talking about?
Okay.
Do we want dismissals too, Ed, or no?
Yes.
No.
I mean, it's interesting, but not really.
Well,
Because
it's just easiest, like, to do, like, for example, within a given year, these are the number of dispositions as a result of criminal convictions, and then we'll show you what the discipline was, so you can see everything.
Sure. That's yes. Fine. Thank you.
I guess to add to it, I don't know if this is possible, Lisa, but thinking about it, especially given the fact of the fingerprinting, is there a way to look at those dispositions related to the year of the conviction, for example?
Okay, let's look at this, we can see.
Well, and I think that that's relevant, Melanie, because I'm getting better results with old, stale criminal conviction referrals than I do with freshmen. So you're right.
That makes sense. Yeah.
Yes, makes sense.
Okay. Are there any other requests? And I don't see any at this time. I think we have our marching orders. So the final thing I was hoping to discuss is if there was, I'd like to make these bi-weekly meetings, and I don't know that we can turn around all of these data requests in 2 weeks. So that we may need to, cancel and go for the next one. But is there a certain, I know everybody's busy. I'd like to keep these around an hour. Is there a day of the week that works for everybody where we can just schedule in 2 weeks and just keep going out there, where we have just an ongoing meeting that if we don't need, we could cancel? Or is that possible?
Tough, Justin.
Okay.
Justin, actually, in my world, time of day is more interesting, or makes me more available than day of week. And that's probably true for all of us. So for instance, I don't have court between noon and 1:30. I don't have court at 8 a.m. I don't have court at 5:30 p.m. So those are my best time slots. And other than that, it's really hard for me to be pinned down.
I'm a big fan of 8 a.m. meetings, just so everybody knows.
I'm in.
I'm serious.
Well, what about Judge Wang and Linda?
Yeah, 8's probably the safest time.
My schedule's quite flexible.
Okay, so is there a day of the week that 8 a.m. works?
I can be flexible for the most part.
Maybe Wednesdays.
Is that
That's as good
Not-
as it
okay.
is.
okay? Okay, I will send out a Wednesday in 2 weeks and then make it a continuing meeting for probably through the end of the year, just to get it on the calendar. And if we don't need it, I will cancel it. And if we do need it, then you'll get the notice like we do, because we have to notice all these meetings because they're public meetings, and we'll get Zoom links. So with that being the last piece, does anybody else have anything else they want to discuss or talk about?
Well, can I just mention the
Sure.
overall, I think, point that, and I don't want to put words in Melanie's mouth, but I mean, a part of all this time pressure is the legislature defining what backlog is. I mean, realistically, is that really realistic? And is how much of that is really driving what we're all sort of perceiving as effectiveness problems, right? So getting the ENECs in, doing, making sure all the, from my end, I have to set the trial within 125 days. Is that all really going back to the single source of how realistic the backlog is, the time that's defined as the backlog? I don't know, maybe is that really where we should be starting this discussion, frankly? I don't know.
Well, I definitely think from our perspective that we feel like in many instances, 180 days is not enough for a case to walk in the door, be properly investigated, go through a pre-filing process, which includes an ENEC,
Right.
and finally,
Right.
yes. And I mean, yeah. And I don't know if there are discussions going on in the commission. I think we heard about it more generally in our introduction. I don't know if there's a plan to look at that more specifically in the ad hoc commission, but yes, it's not reasonable, and it is, and we are very mindful of it. That's one piece. The other piece is the public protection piece. Just the fact that, for that period of time, it's not public, and in some instances, it really needs to be.
And Judge Wang, we brought up the backlog I think it was Fairness. Dag gave a presentation on that a couple of times on that. And these things all tend to wind together, because we also talked about Judge McGill and his self-help materials for those, self-represented people in state bar court. I don't know how much that's going to help alleviate some of that, or, so that they're all kind of working together. I know that, the bar there, I don't know, Dag, you can speak to this, but there was a little bit of an appetite to modify the backlog.
The legislature, in a last conversation that I was a part of with staff to, I think it was Assembly Judiciary Committee, at least acknowledged that the 180-day number was pulled out of thin air, and that they don't know where it came from. They don't know what it relates to, but there it is. We were stuck with it. So at least we got that much from them. Their willingness to modify it is, I think, I think that they're still willing to modify it, but we're in conversations with them about some other numbers that we've been working with.
How about changing it just to take ENEC cases out of the number?
Right. Oh, I like that.
Premise.
Yeah, I mean, potentially, there's the complex designation. We could do an ENEC designation and get some extra time, but it's interesting. I know that I don't know if we plan to bring this back to the backlog to the full ad hoc commission, but I don't think there's not a working group established for that. purpose.
Well, and the board weighed in on the proposed changes. At the July meeting, we ran some proposed changes regarding how we would report timeliness in case processing by the board, and they signed off on those proposed changes. It mirrors time standards that are used in the civil world in the superior courts, unlimited civil case standards, and sort of uses that same sort of framework with saying a certain percentage shall be processed within 3 months, a higher percentage within 7 months, still a higher percentage at the end of a year, and then by the end of 2 years, you're supposed to have them all processed.
The statistics that we're proposing to gather here, are we including the number of cases that go ENEC versus the number that do not?
Seems like it'd be a good baseline number to have. Yeah, I mean, I think you'd want to start from the sort of widest end of the funnel to just know what your different universes are of yes and no. They're either in the ENEC process or they're not, and then start trying to look at how those differ.
I'm sorry, what are the non-ENs? Like what universe of cases are those? Those that go to state court without an ENEC?
Right, I think that's what she was
It's not
suggesting.
requested.
Right. Oh, I see.
Okay. Anything else? All right. I really appreciate everybody's time today, and we will be in touch. This
Thank
meeting
you.
is adjourned.
Thank you.
Ew.
Thank you.